Are you still guilty of a one-punch manslaughter case if the victim died because they refused a blood transfusion? Imagine you're charged with a commonly known charge called one-punch manslaughter, where the facts are you punched someone in the head and that person died a few weeks later, but you later found out the victim refused a life-saving blood transfusion. Are you still the legal cause of that person's death? Are you guilty or not guilty of one-punch manslaughter? Remember, in criminal cases like this, the prosecution must prove both factual and legal causation. Factual causation is based on the but-for test mentioned in a previous post. But for the defendant's conduct, would the result have occurred, as per the case of R versus White? In a one-punch manslaughter case, the answer would be no, and the prosecution would therefore be able to establish factual causation against you. Your punch factually caused the victim's death. However, causation does not stop at the prosecution establishing factual causation against you in this scenario. The prosecution must then need to establish legal causation, because you may argue that there were multiple causes of the victim's death and you did not legally cause the victim's death, so you should escape criminal liability. So, for example, you may claim there were multiple defendants involved in punching or kicking the victim to death, or you may argue the immediate cause of death was as a result of the actions of the victims themselves not having that life-saving blood transfusion. Or you may say there was some intervening act between the culpable act of the punch and the prohibited result, the victim's death, which is the real and legal cause of death. At the heart of legal causation and the debate between the prosecution and the defense is this: was your culpable act, the punch, the substantial and operating cause of the prohibited result, the victim's death, as per the principles established in the case of R versus Smith? Now, the criminal law has refined the concept of legal causation over the centuries into 5 rules or principles for the prosecution to overcome to establish legal causation against you. And if they can't overcome them, then you escape criminal liability. So let me quickly run through those 5 rules, and keep in mind the one-punch manslaughter scenario. You punched once, that's the culpable act. A victim dies 3 weeks later, and the victim's death being the prohibited result. Can the prosecution establish legal causation against you, the accused? Rule 1. The result must be attributed to a culpable act, as per the case of R versus Dalloway. In our example, the prohibited result, the death of the victim, must be linked in some way to the culpable act, the punch. So in this scenario, the punch having connected with the victim's head would mean the prosecution would be able to satisfy this rule. Rule 2, the culpable act must be more than a minimal cause of the prohibited result, not a trivial cause, a substantial cause, as per the case of R versus Paget. In our example, a clenched fist, the punch to the head was hard, not a tap, would mean the prosecution would be able to satisfy this rule. Rule 3, the culpable act need not be the sole cause. It does not matter if there are multiple causes of the death, as long as your culpable act is one of them, as per the case of R versus Benj. Now, in our example, it doesn't matter if different people could be at fault for the victim's fatal injuries. Your codee's kick to the head, but also your punch to the head, causing fatal brain injuries. So the prosecution would be able to satisfy this rule. Rule 4. The accused must take the victim as they find them. In our example, you can't blame the victim for their own death if your punch resulted in their injuries and subsequent death. And this includes if the victim refused a blood transfusion, if they hold such belief, as per the case of R versus Blower, or if the victim had a bone structure or a weak heart or a weak heart condition and dies, as per the case of R versus Watson. You must take the victim as you find them, also known as a thin skull rule. So the prosecution would be able to satisfy this rule. And rule 5, the chain of causation must not be broken. Sometimes, as the accused, you might try to argue that the intervening act, like poor medical treatment, or again, particular actions by the victims themselves, had broken the chain of causation, and therefore you, the accused, should be found not guilty. A not guilty finding may be the finding of the court if the chain of causation has been broken. So please check out the next post, which is all about how the courts go about assessing whether the chain of causation is broken. But for now, remember, in some cases, the prosecution needs to establish legal causation. Your actions were the substantial and operating cause by considering those 5 rules. Feel free to comment and follow criminal law classes for more.